Hello there. My name is Christopher Carlson. I'm a patent attorney and Deputy Managing Director at IPR agency Leitinger in Helsinki. I'm here today to give a talk about IPR in business. Now, the subjects of this talk are mainly two. The first one is what is IPR? And the second one is how is IPR useful in your business? Now let's start with the first topic. Now IPR, that's an abbreviation for intellectual property right. And it's all about a legally recognized exclusive rights to creations of the mind. Now, if you want to put it a little bit more difficult, you could say that an exclusive right is the right to perform an action or acquire a benefit, or to permit or deny others the right to perform the same action or to acquire the same benefit. And if we look at the term creations of the mind again, then if we would like to deepen our understanding of that, then we could say that synonyms of creations of the mind are, for instance, artistic work, innovations, and inventions. Now, let's take a look at some common types of IPR. The first one that usually comes to mind to people is patents. Then we have a so-called petty patent, which in some countries is also called utility models. Then we have trademarks, which is usually quite widely known, and design rights for protection of design. And finally, copyright, which you can see on books and artistic work. Now, the different types of IPR, they are for protection of different types of creations of the mind. Patents and utility models, they are for protection of technology, which we often refer to as inventions. Then we have trademarks for protection of marks, names, logos, slogans, and so forth. Then we have design rights for protection of the external form, that is to say, the visual design of objects, but not, for example, technical solutions comprised therein, only the external form. And finally, copyrights for the creators of original works, such as books and photos. Now, let's take a closer look at what kind of inventions are patentable. First of all, we have a group called products, where we have examples as pharmaceuticals, materials, and so forth. And the second group are the devices. Devices are, for example, paper-making machines, fuel cells, etc. Then we have a third group, which is processes and methods. An example of a process is, for example, a process for preparing pharmaceuticals, or paper, or materials. And a fourth group, which can be protected by a patent, is the use group. Now, a common target of use protection is the use of a known pharmaceutical for an entirely new medical indication. Not everything is patentable. There are certain kinds of inventions that are excluded from patentability by law, for example in Finland and Europe. For example, discoveries, scientific theories, and mathematical methods are as such excluded from patentability. the same goes for aesthetic creations, which on the other hand may be protected by design right. Then we have a third group of schemes, rules and methods for performing mental acts, playing games or doing business, and programs for computers. Now mind you that programs for computers as such are not patentable, but in combination with some technical feature they might well be. And then we have a fourth group, which is presentations of information as such cannot be patented. Now, the list of inventions that are not patentable by the law continues. Also, methods for surgical or therapeutic treatment or diagnostic methods practiced on humans or animals are excluded. Excluded are also processes for cloning human beings and processes for modifying the germline genetic identity of human beings. Further, excluded are also uses of human embryos for industrial or commercial purposes. And finally, processes for modifying the genetic identity of animals which are likely to cause them suffering without any substantial medical benefit to man or animal. They are also excluded. Now, then to the question, how can I get a patent in the first place? Well, that is done by, in writing, preparing and filing a patent application with the desired patent authority, such as the Finnish Patent and Registration Office, PRH. Or, for example, if you're interested in getting a Europe-wide patent, then the European Patent Office. Now then, let's move on to utility models. Now, what may be protected by a utility model? It's basically a lighter version of a patent. That is why utility models are also called for petty patents. Now, when it comes to what is protectable by a utility model, it covers products and devices, but not methods and processes. Methods and processes are excluded from protection in utility models. Now, what are the main requirements for obtaining a utility model? They are quite the same or similar to the requirements for patents. Now, the first one is novelty. The invention that is going to be protected by a utility model has to be novel. And then it has to be clearly different from what is known previously. And as in patents, it has to be a technical solution suitable for industrial use. Now, what are the differences between a utility model and a patent? Now, a major difference is that the term of a patent is 20 years, whereas a term for a utility model is 10 years. Then if we look at the substantial side of the invention, the inventive step requirement is lower for utility models. In patents, it's required that the invention clearly differs from the prior art, whereas in utility models, the invention has to differ clearly. Now, another benefit of petty patents or utility models, if you say, is that no examination is required, only of formal aspects. So as soon as the application is formally okay, it will be registered. Now, utility model protection is not available in the same countries or all the countries as patents, but nonetheless it's available in several countries. For example, Finland, Denmark, Germany, Estonia, Poland, and so on. Now, since no examination is performed, only formal, the registration of utility models is, in most cases and in most countries, faster than the grant of a patent. So if you want protection fastly, you may consider using a utility model instead of a patent. Okay, so now we have talked about patents and utility models, and now let's move forward to trademarks. What may be protected by trademark in the first place, and secondly, how do I obtain a trademark? Now, a trademark is a symbol for distinguishing the goods and services of a company from similar goods and services of other companies. Symbols can be explained as marks, names, logos, slogans, etc. To give an example, I could mention Bass Brewery's logo. It is one of the oldest registered trademarks. It was registered already in the year 1875. If we take a slightly newer registered trademark, I can mention Google's name and logo. Now, how do I obtain a trademark? Well, the safest way is to do it by applying for trademark registration. Another way is by establishing a trademark. That means that you just start using the trademark in your services and your products, and then by that way you establish it, so it becomes commonly known to the public. But usually it's advisable to actually apply for registration, because establishment may be hard to prove. Now, as I mentioned before, not everything is patentable. So there are some creations of the mind that are excluded from patentability, but these can be protected by, for example, in some cases, if they relate to something visually, by design right. Now, if you put it in other words, the appearance of a product or a part of a product may be the object of a design right. Now, everyday items as bookcases, chairs, graphic symbols, even interiors of restaurants and coffee shops can be protected. Furthermore, integral parts of products can be protected. Let's say, for example, fabric patterns, handles of coffee cups, or some certain parts of cars. However, the object of protection must always be a concrete article. For instance, it can't be a plan or an idea or liquid. Now, a design does not have to be artistic in order to be registered, but it may not be simple or commonplace, and excluded are also basic geometrical forms such as spheres and squares. Now, how do I obtain a design right? Well, in Finland, it is by registration at the PRH, the National Patent and Registration Office. Now that we have talked about different types of intellectual property rights, let's take a brief look at how you could make IPR a part of your business. Now, your situation might be that you already have acquired IPR, or that you are about to. Or it could also be that you know that you don't have anything to protect, but you need to be aware what the competitors have. Now, first of all, by obtaining your own IPR, you can get a bigger market share by being able to deny your competitors the right to use your creations, innovations and inventions that you have protected by, for example, patents, trademarks and designs. You could also consider licensing your IPR. Thirdly, let's say that you're not going to acquire any IPR for yourself, but your competitors have some, let's put it, annoying intellectual property right that prevent you from getting as big a market share as you would like. Then you can file oppositions, for example, to in order to revoke your competitor's IPR, and in that way get rid of these kind of business obstacles, so to speak. Now, for doing that, there are available open IPR databases. Open in this respect means also usually totally free of charge. Now, these open IPR databases can be used, for example, for R&D. By searching the databases, you can get a fairly good view on what is going on in the field and what is not worthwhile trying yourself if it has already been done. Further, you could also use the databases for evaluating your own IPR filing and registration strategy. So this relates quite a lot to the previously mentioned R&D issue. If you do, for example, your own examinations of what is known in the prior art, you might see that what you thought was new and inventive has actually already been invented and disclosed. Now, then the third thing is that you can avoid possible infringement of others' IPR by continuously looking at these IPR databases and looking out for IPR not to infringe. And in that way, you may avoid costly legal actions and court cases. Now, let's start with some open patent and utility model databases. Now, if you're interested in finding details of Finnish national patents and utility models, then you should use PatInfo, which is the patent register of the Finnish Patent and Registration Office. Then, if you want to look at basic details of European patents that has been put in force in Finland, then you should look at the FIEP register at the Finnish Patent Office. From Espacenet, you can find patent documents from all over the world, and from the European Patent Office's European Patent Register, you can find procedural and legal status data on patent applications handled by the European Patent Office. As for trademarks and design rights, I have a couple of databases I would like to mention. First one is eSearch Plus, where you can search for community trademarks and community designs. We also have at the Finnish Patent and Registration Office a open design right database called DesignsNet. There you can find basic details of Finnish design rights. The Finnish Patent Office also has a trademark database where you can find basic details for Finnish trademarks. Finally, I would like to mention the European TMView search tool, which is a tool for finding details of trademarks all over Europe. Now, in this talk, I have touched upon different types of IPR that may be used for protecting different types of creations of the mind. Now, as we've seen, patents and utility models are for protection of solutions, technology, whereas trademarks are mainly for branding purposes, and design rights are for protection of design. I have given you some tools for searching different types of IPR. Now, please use these and get out there and try to find something interesting and get inspired and perhaps even innovate or invent something yourself. Good luck. Thank you for listening.